Yes, Judge.
Court is calling 2018 CR 12679 State versus Stephanie Sandoval. Can I have parties announced?
Jason Deerham for the state, Your Honor.
It's Fernando Cortez for Ms. Sandoval, Your Honor.
And are you Ms. Sandoval?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? And did you understand it?
Yes, ma'am.
Are you the same Stephanie Sandoval who was placed on deferred adjudication in 2018 CR 12679 for the offense of assault peace officer or judge on October 4th, 2019 for a period of 6 years and extended a total of 2 years?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition number 22 on or about the 9th day of May 2025 in Bear County, Texas. The defendant Stephanie Sandoval did and there failed to participate in the felony drug court program as ordered by the court in violation of condition number 22.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violating condition.
Any objections to the waivers?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 22, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Judge.
Knowing that, do you still wish to plead true to violation of condition number 22?
Yes, ma'am.
Court will find violation of condition number 22 true. Is there a proposed agreement?
There's a proposed agreement that's unagreed to, Judge. The state's recommendation is to deny the motion, continue on deferred, and to have her attend safe.
And defense?
Which at the top evaluation is recommending ISF, also safety, but ISF, and also an intensive outpatient treatment is an option also based on the top evaluation. I believe that this individual is probably more related to alcohol. I would ask the court to put her on a scram unit, go ahead and allow her through her insurance to get the intensive outpatient treatment and continue. She would probably be done, she gets extended in October. She has a 3-year-old child also being cared for by the mother-in-law. This is a tragic case where her husband deceased during this probationary period and caused some serious trauma to this individual. I would just ask the court, she doesn't have any history of drugs or violence. She doesn't have a DWI. That's why I'm suggesting a scram unit just to monitor the alcohol and see if I believe she's serious about this. If she is, it'll be found out very quickly. A scram unit gonna know that she's drinking, anything like that. I think that's mostly the problem here.
But I mean, felony drug court was going to solve that problem, and she didn't want them to solve it.
She's probably rolling in her right head. But
Yeah.
I bet after 55 days in jail right now, it kind of does something to your brain. And
No, because see, here's the thing. People can't write their own programs. If people could write their own programs, you wouldn't be here. And you've been on this probation since 2018. There's nothing else for the court to help you with. I mean, I offered you to help. You don't want it. The help was felony drug court and you didn't want it. So where we are now is the court is going to grant the motion, find you guilty, and revoke. Does anyone wish to speak to time?
We'll defer to the court, Judge.
Well, only I would ask the court to consider the ISF, Judge. That's a significant treatment. See how she does with that. I mean, it's something that the court can do that goes beyond felony drug court. This is more than that. And we're asking the court then to do more than that and give her the ISF.
Felony drug court is very intensive, and she could have been doing that outpatient. So the court is going to sentence you to 3 years in the prison, give you credit for any time served. The court will request the therapeutic community, and I'll retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Your Appeal with your attorney? Did you understand it?
No.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And your attorney will explain to you what it means that I'm keeping jurisdiction. All right, thank you. All right, who is here on Clinton Dixon? Good morning. Where's Mr. Dixon?
I'm ordered in, Judge. I need to approach on we could get off the internet for just a moment.
Okay, once he comes down, I can take it up.
Okay.
All right. So,
Yours.
sure. Who's here on Ambrosio Cabrera? And where's your client?
I'm here for the state.
Ah,
I don't.
who is the attorney?
Roth Baron.
All right, as soon as he comes back. Who is here on Marlon Daniels? Who's here on John Thurnert?
Mr. Dixon's up here, Judge.
Okay, I'll call Mr. Dixon. Mr. Featherston, I'll take Mr. Dixon up after this. Hello.
Good morning, Judge.
Good morning. Is this criminal trial division or family violence?
It's a CTD case, Your Honor.
All right, so they just finished jury trial.
Yes, ma'am.
So they're a little bit tired, and the next section that's up for jury trial is family violence.
Understood.
So if y'all want the trial, I'll put them back to trial, or if y'all want to pass to.
We will, for some specific reasons, I think it would actually be helpful to do that. So that we can continue to confer.
All right. So how long do y'all expect this trial to last?
Oh, I would say this is probably a 2-day trial.
All right, Ms. Ferguson, 2 days? All right, Ms. Ferguson, I need a 2-day reset for jury trial in this criminal trial division. So here's the thing, you can do a bench trial or you can do a jury trial. If you do a bench trial, if the state proves their case beyond a reasonable doubt, I'm gonna find you guilty. If they don't, I'm gonna find you not guilty. So it's completely up to you.
I mean, obviously.
All right, your jury trial date, I'll make your jury trial date and plea deadline date for August 5th.
Wonderful. Yes,
The
thank you, ma'am.
courtroom's
All right, thank you. Once
procedural
you sign the
calm was
reset form, you're
shattered by a
excused.
revelation so
Sure, wait.
stark
All
it
right, thank you. You
redefined
too.
the entire hearing. In the case of Mr. Palmer, the prosecutor delivered a bombshell. Since his arraignment, the defendant had placed 43 phone calls from jail to the very victim he was accused of harming. This wasn't casual contact. It was a calculated campaign of coercion. The prosecutor detailed the content, explicit instructions on how to contact the prosecutor's office, what to say to get the charges dropped, and directives to avoid verbal arguments that might damage his case. The judge, who had previously revoked the defendant's phone privileges upon learning of earlier contact, was now presented with the disturbing substance of those calls. The defense attorney, having just received the recordings, was caught off guard, admitting he hadn't yet listened to them. The judge, a bit disturbed by what I'm hearing, faced a critical decision. Dismissing the case would only lead to reauthorization and rearrest. Instead, he wielded judicial discretion like a scalpel. He granted the prosecution's request for an adjournment to formally file a witness tampering motion, setting a new exam date for late November. Crucially, he left the defendant's bond in place but his phone privileges revoked and issued a veiled but severe warning. Any future bond motion would be heard, but evidence of interfering with proceedings would make release highly unlikely. This ruling was a masterstroke. It kept the case alive, acknowledged the serious new allegations, and maintained leverage over the defendant, all while preserving the victim's chance for justice. The theme of judicial scrutiny continued with Michael Russell, who waived his preliminary exam for a favorable plea deal to avoid additional charges. His attorney then passionately argued for a personal bond, citing health issues, employment, and family support. The prosecution countered with his history, fleeing from police, injuring an officer during the chase, and a prior record for similar resistance. The judge's analysis was swift and clinical. Despite the sympathetic health claims, the core facts were damning: alleged injury to officers and a documented history of flight from authorities. The judge declared him a flight risk and denied the bond request without hesitation, leaving that determination to the sentencing judge. This session showcased two forms of manipulation: one, a blatant attempt to tamper with a witness from behind bars; the other, a plea for leniency based on personal circumstance. The judge met the first with a strategic adjournment and a stark warning, preserving the sanctity of the process. He met the second with an unemotional assessment of risk and pattern, prioritizing public safety over sympathetic appeals. In both instances, the courtroom's function was reaffirmed. It is not a place where games succeed, but where facts, patterns, and the integrity of justice itself hold absolute sway.